Hi, my name is Jonathan Radke, partner at the healthcare law firm Nelson Hardiman in Los Angeles. In this video, I will be talking about one of California's lesser-known whistleblower statutes, the Insurance Frauds Prevention Act, or the IFPA for short, and its implications for healthcare providers. Traditionally, false claims allegations in connection with healthcare services were brought under the Federal False Claims Act, which creates civil liability for false claims submitted to government programs. In California, however, claims for healthcare services to private insurers are also the subject of whistleblower enforcement. The Insurance Frauds Prevention Act is a false claims statute in California that applies specifically to private insurance claims. Although the IFPA was originally intended to address workers' compensation fraud, a trend has emerged in which it has increasingly been used to address healthcare fraud by anyone who has insider knowledge, and even when the insurance company is not involved. Given this shift in focus, it is important that healthcare providers become aware of this statute and ensure that they have in place a robust compliance program for their private insurance claims. Here is some helpful information to remember about the IFPA. First, when a claim is brought under the IFPA, the district attorney, or more likely, California's insurance commissioner, may intervene and ultimately control the lawsuit. The insurance commissioner may also subpoena records from a provider before a lawsuit is even revealed. Receiving a subpoena from the insurance commissioner may be confusing, particularly for any provider that is not aware of this statute, but it may be an indication that a civil complaint has been filed under seal and has not yet been made public. Second, the IFPA applies to more than just insurers. Any interested person can bring a claim under the IFPA, which, as the language suggests, can be anyone with insider knowledge of fraud. Of course, this can and often does include current and former employees of an organization. Third, the IFPA contains substantial whistleblower protections for employees bringing these types of lawsuits, including, for example, reinstatement and back pay. It is important for employers to be aware of these provisions to ensure against any action that could be construed as retaliatory. Fourth, although California's Department of Insurance takes a broad enforcement approach, some trial courts have already concluded that the IFPA does not apply to healthcare service plans, which includes the majority of the health plan market in California. Rather, the language of the statute technically only covers indemnity insurance as defined under the insurance code. For similar reasons, courts have also concluded that the IFPA does not apply to self-funded plans that are governed by ERISA. Fifth and finally, just like the Federal False Claims Act, consequences for violators are stiff. The statute provides for treble damages, meaning 3 times the amount of each claim for compensation, and penalties of $5,000 to $10,000 per claim. Indeed, penalties are based on the amount of the claim, not the amount paid, so liability can extend on the basis of misconduct even when the claim was never paid by the insurer. That's it for today, and I hope you found this information helpful.